Welcome to our October edition of Voices for the West, a webinar series brought to you by Advocates for the West. My name is Will Shoemaker. I'm Communications and Engagement Director at Advocates for the West. If you're new to our webinars or unfamiliar with our work, we at Advocates for the West are free lawyers for the environment. We work to protect our public lands, water, fish, wildlife, and communities throughout the American West, and we partner with more than 80 conservation organizations, as well as Native American tribes and environmental advocates. The title of today's program is Public Lands Livestock Grazing in an Era of Environmental Rollbacks. This is a particularly timely topic given a number of regulatory changes and court decisions that have occurred in recent months and years, and which we will cover here shortly. We'll also be covering what hasn't changed, and what all of that means for you, folks like you who are with us today, the conservation community, who's actively involved in monitoring and advocating for the health of our public lands and wildlife. We're honored to be joined by some of our close partners and experts in this work, including Mac Lacy, Paul Ruprecht, and Advocates for the West's own Laurie Rule. A quick note before we get started. As an attendee, you will remain on mute throughout the course of today's webinar. However, we certainly welcome your questions, and if a question comes to mind at any point during the course of today's talks, please do feel free to drop it into the Q&A section of the webinar. That's located at the bottom of your screen, and I will point out it's different from the chat. We'll get to as many of those questions as time allows toward the end of today's webinar. And without further ado, I would like to welcome our first presenter, Laurie Rule. Laurie is senior attorney at Advocates for the West and heads our Portland, Oregon office. She has been the lead attorney on our successful efforts defending special places and sensitive species throughout the West from harmful livestock grazing. Welcome, Laurie, and I will pull up slides so that we can get started here.
Thanks, Will. So I'm going to start us off by sort of laying out the laws and the regulations that apply to livestock grazing, many of which are changing right now. So I'm going to talk about what hasn't changed and what is changing to kind of lay the groundwork for the discussions that Mac and Paul will have after myself. And so I'm going to start with NEPA, because that is one of the laws that grazing activists have been using for years to try to tackle livestock grazing. And it's also one of the things that has been under attack recently. So first slide, please, Will. So, NEPA, the National Environmental Policy Act, they amended it a couple years ago, but right now under Trump, Congress hasn't actually made any changes to NEPA itself. So the law is still in place that has existed at least for the last couple of years. And that means that essentially all of the cases that have said, NEPA means that agencies have to take a hard look at the effects of at the environmental effects of all of their actions. That's still in play. So yes, when an agency does an environmental analysis, it still has to take a hard look at the environmental impacts of those actions. Nothing new there. Nothing changed. The other law that I want to touch on, and I'll touch again later, but that relates to NEPA is actually the Federal Land Policy and Management Act, or FLPMA, because in 2015, Congress amended FLPMA with regard to livestock grazing and noted that BLM can renew grazing permits, 10-year grazing permits, without doing an environmental analysis at that particular time, as long as it was simply renewing the permit under the same terms and conditions. But it must do an environmental analysis at some point. And so FLTMA sort of laid out this, what had been happening on a kind of a yearly basis by Congress, saying, okay, you can renew a permit term, you can renew a permit under the same terms. You still have to do an environmental analysis, but you can kind of do it whenever you want. The other thing that was in FLTMA that is still there and hasn't changed is that the BLM can use what's called a categorical exclusion, or a CE, for grazing permit renewal. So in other words, they don't have to do an environmental assessment or an environmental impact statement. They can simply categorically exclude this permit renewal from any actual analysis if, again, the permit is simply renewing the same terms and conditions, and BLM did an evaluation of the allotment and determined that the allotment is meeting rangeland health standards or is not meeting rangeland health standards for reasons other than livestock grazing. So if it meets those conditions, then it doesn't actually have to do a full either environmental analysis or environmental impact statement. It can simply renew the permit under a categorical exclusion. I don't think BLM has been doing that often, frankly, because I don't think BLM has been going out there and evaluating allotments to make these determinations about whether they're meeting land health standards. And I'll get into that a little bit more later. But those things are still on the books, no changes. What has changed is the regulations. For years, NEPA regulations were under the Council of Environmental Quality, and those regulations were in place since like the 1970s. They were well established. Those regulations are now gone. Under this administration, they required CEQ to rescind those regulations. Next slide, Will. So what's happening instead is that agencies are issuing their own regulations, and this is where kind of the significant changes to NEPA are occurring. So Department of Interior, DOI, Department of Agriculture, USDA have issued their own NEPA regulations. They're not technically final yet, but they're basically out there and being implemented now. So I'm going to go through what some of those new regulations are doing. And one difference is that USDA is putting everything actually in regulations under the Code of Federal Regulations, whereas Department of Interior has just issued a narrow set of regulations, and a lot of what I'm going to talk about is actually going to be in their handbook as guidance. But I'm not really going to get into that. I'm sort of just going to discuss the changes broadly, and USDA and DOI, a lot of the changes are similar between the two of them, whether they're actually in regulations or in the handbook. So one of the key things that both of these agencies are trying to do is use more of these categorical exclusions and determinations of NEPA adequacy where they're not actually doing an analysis of a new action. So they're trying to get away from having to do environmental EAs and EISs for a lot of their activities. A determination of NEPA adequacy is basically where the agency says, oh, we did NEPA previously, and what this new action is covered by that previous analysis, so we don't have to do a new analysis. So how are they trying to use CEs more frequently? Well, they are using developing CEs for more categories of action. So a CE is basically where the agency says there's a particular category of action that is not going to have it's only going to have minor effects. It's not going to have any significant effects. We know that. So it's per se, it doesn't, insignificant. It doesn't need any further analysis. So the agencies are broadening the categories of CEs, categories of activities that are going to have CEs. They are allowing agencies to adopt CEs from other agencies without really going through any further process. So in other words, like under the USDA, the Forest Service can adopt CEs from the Farm Service or from, whatever other USDA agencies are out there. They are allowing multiple CEs to cover a project, which seems very sketchy in my mind. But that's one of the changes that they're saying is that, okay, well, you can use like 2 or 3 different CEs to cover an activity, so you don't actually have to do an environmental analysis or EIS. And they can also, an agency can create a new CE or revise an existing CE for one particular project. So they can do sort of a site-specific CE. They have to provide public notice on that, but I do not believe they have to actually allow for public comment. So these are some of the broad broad actions that the new regulations are allowing for to increase the use of CEs. Now, which of these might apply to livestock grazing? Next slide, Will. I'm not sure a lot will apply to livestock grazing, frankly, because honestly, they already had the CE I talked about within FLTMA itself. That's still there. That's on the books. That's a statute. So other CEs that could apply to grazing. So the Forest Service already had a CE that Department of Interior has adopted, and that's what you see on your screen to the left. Implementation or modification of minor management practices to improve allotment condition or animal distribution, like rebuilding a fence, adding a stock watering facility to an existing water line, spot seeding native species, etc. So DOI has now adopted that particular CE from the Forest Service, but the Forest Service already had that on the books. The other thing that I think could come into play in terms of CEs related to grazing are where, for instance, the Forest Service adopts CEs from other USDA agencies. So, for instance, the Farm Service has a slew of CEs that cover all kinds of activities, and some of those could, be translated to livestock grazing management. For instance, fence repair or installation, spring development, tank or trough installation for water troughs, etc. So you might see the Forest Service adopting these other CEs from other agencies to allow them to do these particular projects that are basically for livestock management, even though the CE originated with some other agency like the Farm Service. So that's, I think, a serious possibility of them doing that. Let's see, next slide, Will. So the other thing, can you go back for a second?
Mhm.
I did want to notice, so at the bottom of this slide, it shows that the USDA list of CEs is found at 7 CFR section 1B.4. That's in the Code of Federal Regulations. Like I said, DOI is putting a lot of their stuff in their handbook, and so their list of CEs are actually found in their handbook, and you can access that at that website. They're listed on the bottom of the slide. They have all of their CEs listed. Next slide. So one thing that is still in place is that before an agency can use a CE for an activity, they still have to consider whether there are extraordinary circumstances that might create significant effects. That was in the CEQ regulations. The list of extraordinary circumstances is slightly different, and I think it might even be slightly different between USDA and DOI. For the most part, it's kind of similar to what it was previously. You have to consider whether there's going to be, effects to threatened and endangered species and wetlands and wilderness areas and other special resources and cultural sites, etc. So I think the agency has more discretion in which resources they consider and get more deference in their conclusions about the impacts of extraordinary circumstances, but they still must consider them and draw conclusions about why those things will not be affected and will not lead to significant effects that would require either an EA or an EIS. Another one of the significant changes with the new regulations, in addition to trying to use more CEs, is getting rid of public comment requirements and opportunities in general. So if an agency, if either USDA or DOI agencies uses categorical exclusion or an environmental assessment, they do not need to do scoping. They do not need to provide for any public comment. For environmental impact statements, EISs, they only need to provide for public comment at the notice of intent stage, which is at the very beginning when you really don't even have very much information. So they're really trying to cut out requirements for public comment. Now, they do allow for agencies to decide to allow for more public comment. So the agencies have discretion to allow for more comment opportunities, but they're not required other than for an EIS at the notice of intent stage. So one thing that activists can do is try to push agencies, particularly their local folks, to allow for more public comment on projects because they do have discretion to allow for that. They have to publish a final EIS and a FONSI, finding of no significant impact, and they have to publish final EISs and records of decision. But again, that's like at the end of the process. They don't have to allow for public comment before publishing them. They just have to publish the final product. With a CE, they don't even need to do that. With a CE, they don't need to provide for any comment. They don't even need to provide public notice. They can just start implementing it. So that's going to be, I think, one of the major concerns is how do folks find out if an agency is even like doing a CE, and when are they going to start the project, because there doesn't have to be any public notice, which is problematic. Next slide, Will. So other changes. So in the analysis, an EA does not have to consider multiple alternative actions. They only need to analyze one proposed action unless there are unresolved conflicts about uses of resources. But of course, an agency is going to say, oh, there's no unresolved conflicts. We only have to do one alternative. In their effects analysis, so under the old CEQ regulations, everybody probably remembers you have to consider direct, indirect, and cumulative effects, and there were definitions of those. That's gone by the wayside. And now it says an agency must consider reasonably foreseeable effects. What does that mean? We'll find out. But that is now the language about what they have to consider in their analysis. They also specifically say they don't need to consider effects on climate change or environmental justice. Surprise, surprise. For findings of no significant impact or FONSIs, under the old CEQ regulations, again, the agency had to consider context and intensity factors. So context was like, well, they had to consider it at the local level, the regional level, the national level. And then the intensity factors was that list of 10 factors that indicated whether, it was a significant effect or not. Those are gone. They still have to consider short and long-term adverse effects on various things, such as the uniqueness of the resources and the extent of the impact, whether the impact may set a precedent, what are the land use plan standards that apply, is there a lot of uncertainty about the impacts? So some of those sort of tie to the previous intensity factors. But then they also have to consider, and this is new, they have to consider effects on public health and safety, economic effects, which was never in the list before, and effects on quality of life, which also was not in the list. So those are kind of interesting additions to whether there might be significant effects. And the last thing I'll note on kind of the analysis under NEPA is what I have here on the bottom of the slide. And I think this is one of the key things, even though they're getting rid of all of this other stuff and trying to streamline their analysis and maybe even get away from having to do an analysis altogether, they still must ensure the professional and scientific integrity of their analysis and make use of any reliable data and resources. And they have to identify the methodologies and the scientific sources that they are using and relying upon in their analysis. So when they do, when they are complying with NEPA, they still have to follow these basic principles of relying on science and relying on data. And so I think that's where that's one of the key things that still is at play and is going to be a potential way to challenge grazing activities going forward. So that's kind of the basic nutshell on NEPA and the regulation changes. Now, these regulations undoubtedly are going to get challenged by different environmental groups. I don't know when exactly that's going to happen, and I don't know what the result will be. But until that happens, and until they potentially win, this is what is happening right now in terms of the NEPA regulations. Okay, so now I'm going to move on to some other laws that are still at play. Next slide, Will. Thanks. So we still have FLTMA. We still have NIFMA, the National Forest Management Act. FLTMA governs BLM. NIFMA governs the Forest Service. And one of the key things under these laws is that agencies still have to make sure that their agency actions are consistent with land use plans. So resource management plans for BLM, forest plans for the Forest Service. any activity, even regardless of whether they use a CE or an EA or an EIS, if they are implementing an agency action, it has to be consistent with the direction in their land use plan. Under FLTMA, all activities cannot cause unnecessary and undue degradation. There hasn't been a lot of great case law on this, not really much successful case law as far as I know, but that is still one of the underlying guiding principles of FLTMA. An agency action cannot cause unnecessary and undue degradation. Under the FLTMA regulations, which are still in place, so the grazing regulations are still in place right now. What is, the fundamentals of rangeland health regulations are still out there. So those are the regulations. I think they're at 43 CFR 4180, and they've been in place since like the mid 90s, I think. They require BLM to evaluate allotments to determine whether they're meeting rangeland health standards. So every state has their own rangeland health standards, and it's usually a series of things regarding, what are healthy rangelands and what is required for that. The BLM is supposed to monitor to see if the allotments are meeting these rangeland health standards. If they are not meeting rangeland health standards, then BLM has to determine if livestock grazing is contributing to those violations, or if it's, if their violations are due to some other reason. If grazing is contributing to violations of rangeland health standards, then BLM has to change grazing management within 1 year. So these regs have been in place for a while, and they're still in place. And I think they are also an avenue for activists to really try to push BLM. And at this point, with the agencies completely gutted in personnel, they're not going to be able to go out there and do much monitoring. So to the extent that folks send in monitoring showing that rangeland health standards are not being met, it's going to be harder for BLM to counteract that if they don't have their own monitoring. Now, query whether these regulations are going to stay in place, because we've heard that BLM plans to revise their grazing regulations at some point. We don't know when, but at some point they're going to revise the grazing regulations. Will the fundamentals of rangeland health regs go away? Very possible. But for now, they're still out there. The other related regulation from BLM is the new public lands rule that came out under Biden. That is going away. BLM has already proposed revoking that rule, and I believe that they plan to issue a final decision revoking that rule in about a month or so. So that may get challenged, but that rule is going away. Under National Forest Management Act for the Forest Service, the substantive provision, one of the key substantive provisions under NIFMA, is that the agency has to maintain a diversity of plant and animal communities in the planning area, which is essentially a national forest. In 2012, the Forest Service issued new NIFMA regulations that primarily govern forest plan revisions or new forest plans. And I don't think there's been a whole lot of litigation, because frankly, there haven't been that many forest plans that have come out under the 2012 regulations yet. But those regulations have some pretty interesting language. The Forest Service forest plans must provide for ecological sustainability. And what does that mean? Well, the regulations say it means the Forest Service must maintain or restore the ecological integrity of terrestrial and aquatic ecosystems and watersheds in the plan area. And they must include components within a forest plan to maintain or restore structure, function, composition, and connectivity of ecosystems. So that's pretty good language. Do new forest plans, are they implementing this? I don't know. But they need to be under the regulations. And forest plans also have to include monitoring to achieve the goal that I just read to you. So do forest plans have monitoring? They should have monitoring. And if they do, are they doing that monitoring? So that's one thing to be looking out for on Forest Service lands. The other thing under the 2012 regulations is the Forest Service has to designate species of conservation concern, which are basically species that are imperiled and in trouble. And for those species that are designated as SCC, the Forest Service has to maintain a viable population of that species within the planning area. So again, that's that's another way, another thing to target when you're looking at Forest Service lands and grazing impacts is grazing causing impacts to species of conservation concern. And that's an issue with regard in particular to bighorn sheep, which I deal with a lot. Next slide, Will. So then just have a couple more slides here. The Endangered Species Act is still in play, obviously. Congress so far hasn't gutted that yet. So that means agencies still have to prevent jeopardy to threatened and endangered species. And they still have to prevent take of threatened and endangered species. Take is basically killing them, injuring them, harming them, wounding them, trapping them, etc. And in order to make sure that agency actions are not causing jeopardy or causing take, action agencies have to consult with either Fish and Wildlife Service or National Marine Fisheries Service over their actions, and come out. That results usually in, a biological assessment and a biological opinion. So that all still is happening. What may change under the Endangered Species Act is that the administration has proposed changing the regulation that defines what harm is. So when I mention, you can't take a species, that includes the term harm, which is separate from the term wound and kill and trap and collect, etc. And for a long time, the definition of harm has included significant habitat modification or degradation that impairs essential behaviors such as breeding, feeding, and sheltering. The administration wants to get rid of that definition. They want to get rid of habitat degradation being considered a form of harm under the Endangered Species Act. That has not been finalized yet. They issued a proposed rule. We're waiting for a final rule, and as soon as that rule becomes final, there are groups ready to challenge that. And arguably, I think the statute itself allows for the interpretation of harm to be significant habitat degradation, but we'll see where that goes. And that definitely impacts livestock grazing, because I think a lot of the harm from livestock grazing, particularly related to fish species, is habitat degradation. It's adding sediment to the stream. It's reducing riparian cover. It's increasing stream temperatures, etc. That's all habitat degradation. So that definitely has an impact on analysis of livestock grazing. And then finally, I think this is, oh no, I have 2 more slides, sorry. I'm going to get into a case. The Supreme Court recently issued a case called Seven County. We abbreviate it to Seven County. It was a NEPA case. It was not good for the environmental community. The actual holding was not real broad. The actual holding basically said that when an agency is doing a NEPA analysis, they do not have to consider effects of other actions that are far removed in time or place. So previously, you had to consider cumulative effects of any actions that, were reasonably foreseeable. And the Supreme Court said, well, you don't have to consider effects if the other action is like really far away or it's going to happen much later in time. Those are too far removed. You don't have to consider those impacts. So we'll kind of see how that plays out. But I think the more troubling part of that decision was what the Supreme Court said about deference to agencies and agencies' scientific conclusions and technical conclusions. They basically said courts must give agencies much more deference than what they have been doing when it comes to agency conclusions that are scientific and technical conclusions. However, even with that, they still indicated that basic principles under the Administrative Procedure Act still apply. You still have to have reasonable explanations. You still have to tie the facts in the record to your conclusions, to the agency's conclusions. So all of that still applies. And I think that, again, is where people can continue to challenge livestock grazing. And my last slide is a couple of examples of my cases that I think would still be valid cases and valid, I could get, victories even under the current situation. One was a bighorn sheep case I brought in Colorado, where we challenged the agency's conclusions about the risk of a grazing allotment to nearby bighorn sheep populations. And the 10th Circuit was like, yeah, the agency's conclusions are not supported by what's in the record. And so, it was a NEPA violation. And they said basically the explanation and conclusions were arbitrary and capricious and therefore violated NEPA. And similarly, with my Sonoran Desert National Monument case, it was a similar thing. It was a NEPA case, but basically we just challenged the agency's underlying analysis, saying the record didn't support the science in the record didn't support the agency's assumptions and conclusions. And the court agreed and said, right, yeah, what's in the record is not, is not tied to the agency's conclusions. So I think these types of cases could still be brought and could still get victories even under the current legal landscape, if you're just kind of going back to basic agency principles. They have to tie the facts to the conclusions. So that's it for me. And now we'll move on to some sort of more specific examples from Mac and Paul.
Thank you, Laurie. Our next presenter is Mac Lacy. Mac is senior attorney at the Oregon Natural Desert Association and has represented ONDA and many conservation partners in legal actions in federal and state courts and administrative tribunals. Mac.
Right. Thank you, Will. Thanks, Lori. It's great to be on the Voices for the West webinar series. I'm a big fan of it, so it's an honor to be here. If you move to the next slide, I will just briefly note for those of you who maybe aren't familiar with ONDA, our three-part mission is to protect, defend, and restore Oregon's high desert. And we basically deal with the geography shown on this map. And mostly we deal with the Sagebrush Sea, the BLM managed public lands in southeastern Oregon. And the protect part of the mission is working for administrative or legislative protections for important landscapes. The restore part is getting members and supporters out on the ground to do things like fence removals or wildlife or wilderness surveys, or those sorts of things. And then the defend part is where I come in, the legal action to enforce or defend conservation laws. Next slide, please. So I'm going to talk just briefly today about a sort of a case study following on Laurie's comments. And this case study describes a legal success that we at ONDA have had over the course of the last few years, preserving a network of important sage grouse habitat research areas in southeastern Oregon. I'm sure a lot of folks on the webinar are basically familiar with this, but very briefly, back in 2015, the BLM and Forest Service adopted a whole series of land use plan amendments across the West. So 98 plan amendments across 10 Western states. BLM said it was the largest land conservation effort in U.S. history, and the U.S. Fish and Wildlife Service relied on what they called these unprecedented plans to decide not to list sage grouse as an endangered species back in 2015. All of the plans in all of the states and individual BLM and Forest Service management units were a little bit different from one plan to the next, depending on what the agencies perceived the threats to be, and the conservation needs in those particular areas. In Oregon, we had one very interesting and unique provision where BLM actually decided to close about 22,000 acres of public land in 13 different what they called key research natural areas, or RNAs, to grazing. And the idea was to establish an undisturbed baseline reference areas network in Oregon. BLM pointed out that they actually have almost no such undisturbed, ungrazed reference areas in all of southeastern Oregon. So they really had a big gap in data. And so they describe these closures, this network of closures, as the scientific minimum needed to produce statistically significant information and to support a coherent research plan so that they could apply science-based management to the livestock grazing that the agency otherwise authorizes across about 12 million acres of sage-grouse habitat throughout southeastern Oregon. So all of these quoted phrases on this slide are really important, and we at Ondo were pretty excited about this because, of course, as grazing activists, we'd been asking for more baseline reference areas and more comparison sites all through our organizational history to try to drill down on actual science-based management to see how unique sagebrush communities respond in the absence of disturbance from livestock grazing. Next slide, please, Will. So the problem was that although these closures were supposed to take effect immediately when BLM adopted this plan in 2015, the agency dragged its feet, failed to actually implement the closures, so they kept allowing livestock grazing in these reference areas. And then ultimately in 2019, under the first Trump administration, they decided to abandon the research network altogether uh, and just go back to grazing all these places and not collecting that science. So Onda filed suit. We wanted to try to protect the closures. So we filed suit in 2019, shortly after we filed our lawsuit. Fortunately, advocates for the West won a great decision over in Idaho, and Western Watersheds Project was the lead plaintiff on that case, winning an injunction barring BLM from implementing the 2019 sage-grouse plan anywhere in the West, including in Oregon. So that protected these 2015 research closures in Oregon. Problem, of course, as I said, was that BLM still was sort of dragging its feet and not actually implementing them. So in our complaint, one of our claims was an unreasonable delay claim under the Administrative Procedure Act. We argued that BLM made this decision in 2015 for this historic conservation plan, and there are all these science-based reasons why it was an urgent science need to start collecting this information. But the agency wasn't doing anything. So in 2022, finally, we won a decision from the district court here in Oregon, agreeing with ONDA that the closures were being unreasonably delayed by BLM and ordering the agency to make these areas unavailable to grazing without further delay. And just a side legal note, I think this is perhaps the first court decision anywhere post SUA, this 2004 Supreme Court case, to actually find a BLM land use plan provision can be compelled under the Administrative Procedure Act under this unreasonable delay provision of that statute. You see some case law on 7061 in terms of agencies delaying or failing to implement statutory requirements with a date certain deadline or regulatory requirements. But we couldn't really find any examples where courts had compelled a provision where an agency like BLM had said, we will do X in a land use plan. But this case, we had the right set of facts to establish some good case law there. So that's something that advocates and other attorneys could look at in the future in terms of looking at specific land use plan requirements that an agency might be sort of shirking or avoiding. Okay, so we won the merits decision, and then in the following spring, the court adopted a stipulated remedy. ONDA and BLM agreed on a series of measures to actually keep the livestock out of the key RNAs and some compliance measures and some reporting measures. And so that was great. These places were finally ungrazed by December of 2022. So it only took them 7 years after the 2015 decision, but great ungrazed now. Next slide, Will. So ungrazed in 2022, and then full grazing seasons or periods in 23 and 24. Unfortunately, then at the close of the Biden administration, BLM amended its sage-grouse conservation plans, or ARMPAs, that's the acronym we use, for the third time. So In the 2025 ARMPA, BLM tried to backtrack again, and this time they tried largely to abandon the key RNA network, dropping it from the 22,000 acres down to about 3,700 acres and reducing it from 13 separate, unique, ungrazed areas down to just 8. Um, so Onda filed suit. We're trying to, again, protect the full, robust 2015 monitoring network. And we really focused on the fact that BLM had not explained its change of course or its reversal of policy. Um, BLM sort of said that it wanted to make these changes for management reasons, making it easier to manage grazing, a little bit of language about how maybe they didn't think that all these ungrazed reference areas were necessary anymore, but they never really looked at their prior findings that this 13 area, 22,000 acre network was the statistical and scientific minimum that was needed for coherent research. And the judge took them to task on that and said, if you're not going to explain why the exact same set of facts is leading you to make the exact opposite decision now, then that's arbitrary and capricious decision making. So we won an injunction earlier this spring, keeping the closures in place. We're in the process of briefing the merits of our claims now. I noted at the bottom of this slide, just in passing, there was a separate case brought by one of the ranchers who had a permit to graze on an allotment that contains part of one of the 13 QRNAs. And basically, Cahill Ranches wanted to also get rid of the 2015 grazing closures. So in that case, Onda intervened on the side of BLM again to defend the 2015 closures, and we won that case. The court agreed with BLM and Onda there and said the 2015 plan was lawful, and BLM has plenty of discretion to set aside areas and even close them to livestock grazing in order to collect data that the agency says is valuable and needed for science-based decision making and to fulfill all of its obligations under FLIPMA and other statutes. Um, okay, next slide. And I'm going to wrap it up so we can get to Paul. Just briefly, next steps. That scientific research is finally set to happen, especially if we can continue on and win on the merits of our claims in this case. But professional scientists have been understandably hesitant to set up study plots and, seek grant money and that sort of thing because of the uncertainty. Even though these places have been actually closed to livestock for a few years, there's still this sort of cloud of litigation and BLM flip-flopping back and forth. Hopefully we're getting closer to the day where there's enough certainty that scientists and the agency itself and organizations like Onda and concerned citizens can go out, monitor these areas, set up some study sites, and then in the short term, just for the members of the public and grazing activists, there is always a need to get out to these places, which are in some of the most remote corners of southeastern Oregon, and do some watchdogging, make sure they're actually remaining ungrazed, but also do some monitoring and help BLM to understand what parts of these areas need some fencing or some other things to make sure that they're actually a hard and fast barrier so that the baseline reference information is useful and not sort of reset to zero every time a herd of livestock wanders through the area. So there are always great reasons to get out there on your own or working with a group like Onda to help support these closures. And then ultimately that information will help BLM to make better management decisions with regard to grazing throughout the rest of Oregon and beyond. So I will stop there and turn it over to Will and Paul. Thanks.
Thank you, Mac. Our next panelist is Paul Ruprecht, who is Nevada Director for Western Watersheds Project. Paul joined WWP in 2013 as a staff attorney and later became the Nevada director. Paul.
Thank you, Will. So I'm going to talk about how some of these policies impact participation for conservation groups and the public. And the first thing I'd say is that it's not clear exactly how much the NEPA regulation changes are being implemented in grazing yet. But these latest changes are part of a longer term erosion of public process in livestock grazing administration generally. And the worst of which was the changes to FLIPMA that Laurie talked about that have reduced NEPA for grazing permits virtually down to a trickle. But I'll talk about some good practices regardless, and some of these may become more relevant as time goes on. So next slide, please. The first thing could be finding out that a project is even planned. If there are reduced notice and comment opportunities, it may be difficult to even know what agencies are proposing before they issue a decision. So for BLM, definitely the most important way to stay informed is to request what's called interested public status. And basically what that is that you can ask BLM to be notified of anything proposed for a particular grazing allotment. It goes by allotment. And anyone can do this. It's provided for in the BLM grazing regulations. So unless they amend those or until they amend those, this won't be directly affected by changes to NEPA. And once you're on the interested public list for an allotment, then you should be notified of any grazing permit changes, range infrastructure, fire rehab, vegetation manipulation, preference transfers, anything like that. So on the Forest Service side, the schedule of proposed actions, or the SOPA, is a website for every national forest broken down by ranger district. And it's updated quarterly with projects that are planned or underway. And I understand the SOPA may be decommissioned, but for the time being, it has been regularly updated, at least for the forest that I'm paying attention to. And so this is definitely something to keep your eye on. If they remove the SOPA, I don't know what the best way to find out about grazing projects on Forest Service lands will be. But for now, this is still the same place, or the best place, sorry. Other things that have been really helpful for me are talking with agency employees and developing good contacts, both at the BLM and the Forest Service, the land management agencies, Fish and Wildlife Service in some cases, and the state wildlife management agencies. In my experience, they've been very helpful for getting information. And then keeping your ear to the ground in any way you can is a good idea, including, listservs, local newspapers, Google alerts, social media. I do feel like it is getting harder to find out about grazing proposals, or I hear about them late. Even if I'm on an interested public list, there can be delays. So, try to find out, try to keep your multiple avenues open for finding out about things that might be going on. And then finally, FOIA. This is not probably something that, a member of the public is going to rely on necessarily, but it's important for conservation groups to do systematic FOIA requests for grazing records, in my opinion. And one example of using FOIA to find out about grazing actions that WWP has done recently is that we found on multiple forests across the West, the Forest Service has been issuing temporary grazing permits, which normally would just be for a 1 year duration, but they're issuing them year after year to the same permittees, so that they're basically, functioning as a term grazing permit with no environmental analysis at all. And so we wouldn't have known about that except through FOIAs. Next slide, please. Once you're aware that a project is underway, you can submit comments even if a comment period hasn't been provided, or if you're not sure if there will be a formal comment period. I've done this a few times recently for one project that I know BLM is working on an EA for. I submitted essentially scoping comments, asking the agency to consider certain issues and proposing alternatives. And then at the same time, I requested that the agency would provide for a formal comment period. But in the meantime, there's nothing preventing submission of comments on your own accord, unsolicited. So I think that that's a really important strategy. And even outside of a comment period, if you visit an allotment or out on the landscape and you want to submit information to the agency, ask them to include it in the grazing permit file for whichever allotment you were on. It's a good idea to ask that your comments and data be added to the record. And then Mac reminded me to note this, that for citations, for references that you include in comments, remember that those literature and papers and anything you cite needs to be submitted directly rather than just cited if you want it to be included in the administrative record. Next slide. So here's just a few general points on commenting, and I know that some of these have been discussed pretty widely as best practices given the new threats to NEPA, but I just wanted to briefly mention them here. If you're going to do include NEPA citations, then citing to the NEPA statute itself, which Laurie noted, has not changed, is a good idea, or case law that predated the CEQ regulations. But overall, raising concerns with specific resources is probably more important than articulating what the actual procedural violation might be. So don't worry if you're not working with a lawyer. Firsthand information is always good. Like I saw this out on the land, because agencies are short-staffed and they might not be out in the field as much now. So I think that data from the public is more important than ever. And then focusing on the substantive standards from the statutes and regulations that Laurie discussed, FLIPMA, NIFMA, and ESA, and then as well as handbooks and specific land use plan standards like those from the ARPA. So in general, kind of maybe focusing less on procedure, more on resources. Next slide. So in the grazing context specifically, there may be additional opportunities to participate that aren't strictly related to NEPA. And under the fundamentals of rangeland health regs that Laurie mentioned, a land health evaluation is usually going to be done by an agency before a grazing permit is fully processed. And that is true even if the permit is going to be reissued under a categorical exclusion. So sometimes I guess often I would say in my experience, the BLM will put out a draft of the land health assessment for the public to submit comments on or data. And it's not the rule, but they also sometimes invite the public to join when they do the assessments in the field. So watch out for those opportunities. And again, if you're on the list of interested public for an allotment, you would be advised of the land health process. And if you're aware of an imminent grazing decision for an allotment, and you have the opportunity to comment on a land health assessment, you should probably treat it as the main chance you'll have to comment just in case, and treat it sort of as NEPA comments, because who knows whether there will be another opportunity to formally comment. Next slide. So finally, there are a couple other pre-decisional steps in the administrative process for a grazing decision that can be used to raise issues and submit information, even if there haven't been prior opportunities to comment. And so these are things that I think could become more important going forward with reduced comment opportunities. And so a grazing protest on the BLM side, the BLM grazing regulations provide for issuing a proposed decision before a final decision. And any interested public, so again, a good reason to be interested public on an allotment, can submit a protest to that proposed decision. And if there aren't any protests, then just by function of time, after 30 days, the proposed decision becomes the final decision. But if there are protests, then the agency has to reconsider the proposed decision, and it has to respond to the protest points. And so a protest normally has been kind of a last opportunity to try to persuade the agency to do something. But going forward, this could be, an additional opportunity, or maybe the only opportunity before a decision is issued. So, and then the Forest Service has a similar process. They're a little bit more strict issue exhaustion. And so that's something to keep in mind. But if they haven't provided an opportunity for earlier comments, then that, the requirement to base objection points on previously raised issues shouldn't apply. So that's all I have for now.
All right. Thank you, Paul. Thank you, Laurie. Thank you, Mac. We have a number of good questions here from our attendees, and we're going to get to as many of these as time allows here in short order. I'll pose the first, and that is, what are some reasons lands would not meet standards due to causes other than grazing?
Well, I've
Well,
known, I've seen excuses like, Mac, you probably know this more than I do, and Paul, but like drought, they always claim that, like, oh, it's really due to drought, not livestock grazing. Or they might say, oh, it's due to off-road vehicle use. It's not really grazing that's causing the problem. It's all of the ATV use that's going on. Those are two reasons I can think of off the top of my head why they might say it's not grazing related. I don't know if you guys have other thoughts.
Yeah, the another common one I see is they say past livestock grazing. So grazing that occurred outside the current permit term, they feel that they can discount that because it wasn't part of, the current authorization.
Okay. Next question. Is there a way to challenge an agency claim that there are no unresolved conflicts? of interest. And there's a second part to this question as well. What qualifies as a quality of life consideration? Who wants that one?
Well, as to part two, quality of life consideration, who the hell knows? I mean, like, this is new language that they put in, the new regulations, and there's, I think it's to cater towards sort of the other side, not our folks. But that's just my personal interpretation. So I think it remains to be seen what that means.
Okay. Next question regarding the 4180 requirement to make changes by the next grazing season. If livestock are the cause of failure, the BLM can also simply initiate a NEPA process and satisfy that action requirement without actually making any changes on the ground. I've seen this done in Idaho on at least one occasion. In other words, the requirement to act can be satisfied without actually changing anything on the ground. My understanding is that this is unfortunately a completely legal move. Is that correct?
I would say the part that being required to take appropriate action within 1 year, beginning a NEPA process or issuing some sort of a process, I think satisfies that. I do think that um, there's a substantive aspect to that too, though, where appropriate action means making some changes. Oftentimes they'll try to make what we would consider maybe minor tweaks, or include fencing or just change timing, that type of thing. But in my experience, there have been some tangible change normally, eventually.
Yeah, I think it's a little bit of an open question what that means. I mean, in our Idaho Watersheds Project versus Hahn litigation, like, we argued that they didn't take appropriate action within the next grazing year because they didn't change grazing at all. But they didn't really make the argument at that time that, oh, well, just initiating a NEPA process satisfies that burden, where I think that is their position now. And as far as I know, there hasn't been any litigation directly answering that question, like in a black and white manner. So I think it's a little bit of a gray area.
Yeah, I would also point out the BLM's handbooks and manuals on the 4180 regs, which might be a helpful place to look for seeing what the agency says are the types of actions it can choose from to make that type of the types of meaningful changes to make significant progress toward achieving the standards. We litigated a case way back in around 2004 with ONDA, sort of pressing BLM on some of these issues about whether the changes they were making in one particular plan were meaningful enough, but we didn't prevail on any of those claims in the case, so I don't have anything additional to offer in terms of a great path forward, but referring back to those handbooks and manuals might be helpful.
Okay, we have a number of questions related to land health assessments, and I'm going to try and combine a couple of these, so bear with me here. First off, is there a good way to track land health assessments being released other than being an interested person for particular allotments? I know the BLM has an LHA database, but I have found it unwieldy to navigate. Second part of the question, how do I find the most recent land health assessment for a Forest Service allotment in Oregon?
The Forest Service doesn't have to comply with the fundamentals of range land health, I don't believe. Am I wrong about that? Or I think that's just a BLM. That's just a BLM thing. So yeah, it doesn't apply to Forest Service. And then I'll let you guys talk about the first.
I'm not aware of the land health assessment database. There is, BLM's main sort of NEPA clearinghouse is their e-planning site, and that's where I would typically see a land health assessment or evaluation posted for, as part of a grazing permit renewal process. But apart from that, I don't. Uh, Peer maintains a really good database that can help provide the status, show you when a particular allotment was last evaluated and what the outcome of that was, what standards were met or not. So it's kind of piecemeal, you have to really pay attention, and being an interested public is helpful.
Yeah, and one other thing I would add to Paul's comment there is that it not helpful to us, but it actually can be different from one BLM district to the next because they can take their own approach. So in Oregon, for example, the Vail district groups together large geographic areas. They call them GMAs or geographic management areas that are hundreds of thousands of acres and usually include a handful of grazing allotments. And they do their land health assessments in these big areas. That makes a certain amount of sense because maybe they cover a particular watershed or a particular upland landscape. But then over on the Burns district and the Lakeview district, I've generally seen the land health assessments done just on a allotment by allotment basis. So what you're looking for when you're doing your research, I guess you just have to be aware that it's not always going to take the same form from one place to the next. But I do agree with Paul that e-planning it's a little clunky to work with, but it's probably the best way to try to track down things that are specific to whatever BLM is doing or planning on a given grazing allotment.
Yeah, I will note that Paul mentioned the peer analysis, and they've did a report not too long ago. And peer stands for Public Employees for Environmental Responsibility, and they have done some good analyses.
One other question on land health and assessments, and that is the frequency with which they are required to be done. Is it annual?
No, I mean, they're supposed to do it before they do a NEPA analysis that they're supposed to do for permit renewal. But again, under FLTMA, like they can renew the permit and do their NEPA analysis whenever the heck they want. So that means they can kind of do their land health evaluation whenever the heck they want, which is a problem we've been trying to get at. A problem I tried to get at with a case I brought under the Biden administration, and we got a settlement with a pretty good instruction memorandum that the Trump administration just immediately rescinded. So it's a very difficult problem trying to force BLM to do land health evaluations and NEPA analyses on grazing permits. It is not an easy road to hoe, for sure.
Yeah, when just one other point to that, I mean, there are many allotments. I think the Nevada may be the worst, but there are many allotments that have never had a land health assessment or a NEPA analysis. That's a fairly high percentage of allotments in Nevada. And there is some really good data on WWP's website that show by state which allotments have been evaluated and what the outcomes were. But
another question, perhaps related to data, regards analysis requirements, and is there any agency guidance for deciding what data are reliable? The person who posed the question notes that it seems like now they can just decide arbitrarily which data sources to use. Any thoughts on that?
Well, I mean, it probably depends completely on the context, what situation you're dealing with, whether you're looking at a grazing permit renewal or a land health assessment or some other project that's directly or indirectly related to grazing, like grazing infrastructure, vegetation management. But I guess maybe the best first place I would look, regardless of the situation, is the land use plan. So if talking about the BLM realm, I would go to the underlying land use plan. And if we're talking about sage-grouse concerns, then go to the ARPA portion of the plan. And there's for that anyway, for that resource, there's pages and pages of very specific requirements and numeric metrics like certain buffers around Lex where certain activities are either prohibited or supposed to be avoided. So that's probably maybe the first best line of trying to see what the agency itself has said in terms of what it considers to be some sort of binding and therefore reliable piece of data. I don't know if Laurie or Paul have other ideas on this one.
I know for like riparian stuff, I don't know, and I don't even know if they still use this, but for a long time, like the MIMS data, the multiple indicator monitoring data was sort of their standard for monitoring riparian areas. And a lot of times they have, whether it's in the underlying land use plan or simply in like their handbook or their manual, they talk about, okay, yeah, these are the things we're supposed to be monitoring. We're supposed to be monitoring stubble height and woody browse and bank stability or bank alteration or these various things. And if they're not doing that monitoring, or if they're doing that monitoring but they're not using the guidance that has been mentioned, like, oh, they say themselves that they're supposed to be doing riparian monitoring using the MIMS protocol, but then they're not using the MIMS protocol. Like, those are ways. But I will agree that, like, right, I mean, particularly under the 7-county decision, they're going to get a lot of deference in what data they rely on and whether they, if they claim it's reliable, it's going to be, harder to undercut that, I think, than it even used to be. So, yeah.
We have time for one more question. I apologize. We have many more questions, but unfortunately are out of time for today's webinar. And it was pointed out that I posed a question which wasn't answered. So I will re-ask this one to see if any of you all have any thoughts on it. And it regards NEPA, is there a way to challenge an agency claim that there are no unresolved conflicts of interest?
Say that there are unresolved conflicts and point to whatever data you can showing that they're not considering, things they should be considering. I mean, I think that's kind of where, again, you can turn back to a forest plan or an RMP and look at the desired conditions and look at the directives and the goals and the standards and guidelines for resources, whether it's riparian areas or fish and wildlife. And if they have various goals and desired conditions, and they have either their own monitoring or you submitted monitoring showing that they're not achieving those, then you could at least make the argument, hey, there are unresolved conflicts because on the ground, this is what it looks like based on your data or based on, photographs we've sent in. You're saying there's no problems. We're saying there are problems. That's an unresolved conflict. So whether they, agree with you or not, you can at least point to things in the record that may be contrary to their conclusion. And then, is that a basis for a potential legal challenge? Sure. Will you win? Who knows? But I think, it's a valid argument.
Thank you, Laurie and Mac and Paul, for your insightful presentations and talks today. And thank you for our attendees for your thoughtful questions. I will say that this important work that's being done by groups like ONDA and WWP and Advocates for the West, it relies on your support. If you do feel inspired by today's webinar, we hope you will give a gift to help us continue this important work challenging harmful livestock grazing on our public lands. I will be sending a follow-up email that includes a link to the recording of today's webinar on YouTube. Please do feel free to share it with folks who you think might be interested in this work. And do please stay tuned in coming months for information on future Voices for the West webinars as well. With that, I hope everyone has a wonderful afternoon. Thanks, everyone.
Thank you.
Thanks.